systems manager for a local technology contractor. He served in the U.S. Navy from 1993 to 2000. After his service, John moved his family back to Northwest Ohio. You're an Ohio native. Well, the man behind the costume is an Ohio native. He has two children, Lauren, who is at Kent State, and a son who is a junior at Ohio State. And his wife, Amy, just completed her bachelor's degree at BGSU. John's life motto is knowing is better than not knowing, and he has been actively studying American history passively for the past 25 years. So that's about someone named John Raymond. This gentleman will now be talking about the Constitution.
Good morning. This new technology and you new people are very strange to me. Forgive me while I prepare my notes. Good morning. I've been asked to come from my heavenly repose to speak with you this day about the foundation of this nation, the great document, the Constitution of the United States of America. I come across many miles and many years. My name is William Jackson. I was selected as secretary of the Constitutional Convention by my friend Alexander Hamilton. He chose me from among the 55 men assembled that summer of 1787. They entrusted me with the duty of recording the proceedings and to furnish such documents as may have been necessary, and to destroy those documents and writings they wished removed from consideration. Over the course of that long summer in Philadelphia, these men debated and discussed, cajoled and coerced, fought and agreed on a framework for a nation that was then in its infancy. That we are sitting here today, you strange people in your strange clothing, is a great testament to what we have done. We are in this area, the Western Reserve, and it is a testament to the efforts that we made. My duty today, as called by this strange committee, is to imbue you with a sense of what the men and myself intended to thunder and roll down the years, to resonate onto generations unknown and unknowable as we assembled in that hot and tight quarter in the largest city in the new nation. I could not know, nor could my compatriots know that summer, what we had wrought. And now, some 230 years later, many of you know these words, and if you want, you may repeat them with me. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. As this preamble states, these were goals we had at heart when we undertook the work of building a frame around which and over which your great nation grew. We did have foresight to recognize many challenges would come, that the circumstances of life and modernity would be fraught with challenge and with promise of new opportunity. The signers, the debaters, the men, most rich and most learned, were aware of pitfalls that would be ever present as time would move inexorably on. We did our best. I cannot claim credit for any great part of my own. I was to act as recorder, and my contribution is only that I kept tidy notes. Our challenge was made ever more great by the context of our times. We lived under the auspices of our original founding document, the Articles of Confederation, or as you may have heard it called, the Articles of Confederation and Perpetual Union. This document, while crucial to the establishment of a nation-state in a time of war with our colonial masters, the British, would not bear the weight of the nation forming and growing as individual states. Unwieldy as it was in its lacking of cohesive agreement among the dissimilar interests of the various inhabitants. For 8 years before we adopted the new United States Constitution, we struggled with its requirements that all states must agree to any changes and that the states themselves had primacy over their inhabitants with no real obligation to the whole of all the states. This was a document that allowed us to separate from England, but did not provide for the overall success of a combined and united states. Our other contextual considerations were common law, around which most of our legal framework was based. We used in these colonies and newly formed states English common law in our agreements or disagreements with our fellow state residents. What became most problematic was the enforcement and acceptance of common law in a nation with no sovereign. It had previously been the monarch, and now, with no king and no overriding ultimate control, there was only agreement and precedent in common law. This would serve only locally, but in debates among the states, it did not serve well. We also had just ever so recently separated from this monarchy, and none of us was anxious to reestablish one. The question became one of, but how? How shall we balance the requirements that the government could and must rule, but not rule so tightly as to establish an oppressive regime? How to balance the benevolent structure that could serve all people against the possibility that that same government enforces its rule in tyranny? Much debate was spent on this topic, and the resolution was a simple one. It's extremely delicate, but like a triangle it would become, it could bear the weight of this necessary balance. The brilliance of the outcome of this result is summarized by a child's game, the game of Rochambeau. Rock, paper, scissors. Paper covers rock, rock breaks scissors, scissors cut paper. So it would be three co-equal branches, three forces that would counter the other and prevent any from outweighing the one. A legislative branch, not unlike a parliament, to make the laws for the nation, with power to overrule the executive branch in those cases where the law or circumstances would require it. An executive branch, and not a king. General Washington would prove to be a fit and fine example of what this role must be, an executive that would enforce the laws of the land to establish the rule of law and enforcement of the same. Then a judicial branch to adjudicate the laws made by the legislative branch and rule on the validity of these laws and enforcements. Some of the mechanisms within the document also buttress these separation of powers. For example, the executive nominates justices of the courts, while the legislative confirms them to their positions. Many other checks and balances were enshrined in the document, which is here, available to you all. I invite you, following, to pick one up. The printing is very small. It's amazing. In the course of one afternoon's reading, you could consume the whole of it, not only the original work, but also those amendments that time had necessitated the addition thereof. Lastly, I will say of the outcome of our endeavor this: we hope to have created a document that is a declaration of our inalienable rights, that these rights are endowed by our creators, that they are foundational to the creature of man. Some great time and much blood would be spent to make this true for all men and all races, and the struggle will continue to maintain the balance of the rights of people versus the rights and responsibility of the state itself. That you are sitting here now, so many years later, eases my soul some to know it was not in vain or in waste. As some small measure of the assistance to this effort, I offer you the following primer as a small guide, the language so eloquently spoken by the delegates stripped for your more modern ears. What follows is a summary of the 7 articles that comprise the original article. Article 1 establishes the first of the 3 branches of the government. It is the legislative. Section 1 gives Congress its power and limits. Congress is the branch of the government that can make laws for the country. This article also creates 2 sections of Congress, the Senate and the House of Representatives. Section 2 defines the House of Representatives as the lower house of Congress. It establishes a minimum age limit of 25 years and establishes that people themselves will elect the members for 2 years each. The members of the House are divided among the states proportionately in relationship to their population. Some portions of this have later been changed. The leader of the House is the Speaker, and he is chosen by its members. Section 3 defines the upper house of Congress, or the Senate. Again, it establishes some minimum requirements, such as a 30-year age limit. Senators were originally appointed by the legislators because we thought that wise. This has later been changed. Each state has equal suffrage in the Senate, meaning that each state has the exact same number of senators, 2 each, regardless of population. This section also introduces the vice president as the leader of the Senate, also called the president of the Senate. He only gets to vote in the case of a tie. Section 4 says that each state may establish its own methods for electing members of the Congress, and mandates or requires that Congress must meet at least once a year. they would choose not otherwise. Section 5 says the Congress must have a minimum number of members present in order to meet, and that it must set fines for members who don't show up, which happens. It says that members may be expelled, that each house must keep a journal to record proceedings and votes, and these records are available to the public. Section 6 establishes that members of Congress will be paid, that they cannot be detained while traveling to and from Congress, and they cannot hold any other office while serving in Congress. Section 7 details how bills become law. First, any bill for raising money, such as taxes or fees, must start out in the House. All bills must pass both houses of Congress in the exact same form. Bills that pass both houses are sent to the president. He can either sign the bill, in which case it becomes law, or he can veto it. In the case of a veto, the bill is sent back to Congress, and if both houses pass it by a 2/3 majority, the bill becomes law over the president's veto. This is known as overriding. There are two other options for veto for the president. First, if he neither vetoes a bill nor signs it, it becomes law without his signature within 10 days. The second option is called a pocket veto. It occurs if the Congress sends the bill to the president and they then adjourn. If the president does not sign the bill within 10 days, it does not become law. Section 8 lists specific powers of Congress, including the power to establish and maintain an army and navy, to establish post office, to create courts, to regulate commerce between the states, to declare war and to raise money. It also includes a clause known as the Elastic Clause, which allows it to pass any law necessary for the carrying out of the previously listed powers. Section 9 places certain limits on Congress. Certain legal items, such as suspension of habeas corpus, bills of attainder, and ex post facto laws are prohibited. No law can give preference to one state over another. No money can be taken from the Treasury except by duly passed law. And no title of nobility, such as prince, marquis, duke, or king, will ever be established by the government. Finally, Section 10 prohibits the states from several things. They cannot make their own money. They cannot declare war or do most of the other things prohibited in Congress in Section 9. They cannot tax goods from other states, nor can they have navies. Article 2 establishes the second of the three branches of government, the executive. Section 1 establishes the office of the president and the vice president and sets their terms to be 4 years. Presidents are elected by the Electoral College, whereby each state has one vote for each member of Congress. Originally, the president was the person with the most votes, and the vice president was the person with the second most votes, though this is later changed. Again, there are also certain limits placed on the president. He must be 35 years of age. He must be a natural-born citizen, and he is to be paid a salary which cannot be changed up or down while he serves in office. Section 2 gives the president some important powers. He is commander-in-chief of the armed forces and of the militia of the states. He has a cabinet to aid him and can pardon criminals of his choice. He makes treaties with other nations and picks many of the judges and other members of the government, all with the approval of the legislation. Section 3 establishes the duty of the president to give a State of the Union address, to make suggestions to Congress, to act as head of state, to receive ambassadors and other heads of state, and to be sure the laws of the United States are carried out. Section 4 briefly discusses the removal of the president, called impeachment. This section defines these impeachable offenses as treason, bribery, and other high crimes and misdemeanor. To be impeached and removed from office, the House and Senate must find that the official committee had committed one of these acts. This has been done twice in your history, once to Andrew Johnson and one to William Jefferson Clinton. Article 3 establishes the third branch the third of three branches of the government. Section 1 establishes the Supreme Court, the highest court in the United States. It sets the terms of judges of both the Supreme Court and lower court, that they serve as long as they are on good behavior, which usually means for life, no justice, and only a few judges have ever been impeached, as I hear. It also requires that judges shall be paid. Section 2 sets the kinds of cases that may be heard by the federal judiciary, which cases the Supreme Court may hear first, called original jurisdictions, and that all other cases heard by the Supreme Court are by appeal. It also guarantees trial by jury in the criminal court. Section 3 defines, without question, what the crime of treason is. This was no small measure in our time. Article 4 of the Constitution talks about the states. States have the power to make and carry out their own laws, state laws that are related to the people and problems of their areas. States respect other states' laws and work together with other states to fix regional problems. This article talks about what responsibilities and duties the states have, along with what responsibility the federal government has to each state. Section 1 mandates that all states will honor the laws of all other states. For example, if a couple is married in Virginia, they are also considered married in New York, or that someone convicted of a crime in Pennsylvania is considered guilty in Connecticut. Section 2 guarantees that citizens of one state be treated equally and fairly like all citizens of another. It also says that if a person accused of a crime in one state flees to another, they will be returned to the state they fled from. This section has a clause dealing with fugitive slaves that no longer applies. Section 3 concerns the admittance of new states and the control of federal lands. Section 4 ensures a Republican form of government. In this case, Republican is synonymous with representative democracy, and both of which are opposed to a king or an aristocracy. The state derives its power from the people, not from the government, and guarantees that the federal government will protect the states against invasion and insurrection. Article 5 of the Constitution says the Constitution can be changed. This new amendments added to the U.S. Constitution, and with the approval by a 2/3 vote in each House of Congress and 3/4 vote by the states. Does anyone know the last? I understand in the year 1992 was the last time you amended the Constitution. It was. Article 6 of the Constitution concerns the United States itself. First, it guarantees that the United States under the Constitution would assume all debts and contracts entered into by the United States under the Articles of Confederation. It sets the Constitution and all laws and treaties of the United States to be the supreme law of the country. Finally, it requires all officers of the United States and of the states to swear an oath of allegiance to the United States and the Constitution when taking office. Article 7 of the Constitution was presented to George Washington and the men at the Constitutional Convention, September 17, 1787. Representatives from 12 of the 13 original states signed the Constitution. Only 9 were required to ratify it. From September 1787 to July 1788, the states met, debated, and finally voted to approve the Constitution. Immediately upon completing the Constitution, it became clear that there was missing within it the foundations mentioned previously, that the rights of each person within the United States must be preserved, and that the rights of the government could not readily be expanded. Therefore, the Bill of Rights was introduced. These became the first 10 amendments to the Constitution written by my dear friend James Madison in response to calls from several states for greater constitutional protections for individual liberties. The Bill of Rights lists specific prohibitions on governmental power. There were among us 2 general ideologies characterized by what would become their political party names, the Federalists and Anti-Federalists. This was much to the chagrin of General Washington, who abhorred political parties and warned of the danger of parties preferring unity to factional infighting. One of the many points of contention between the Federalists and Anti-Federalists was the Constitution's lack of a Bill of Rights that would place specific limits on government power. Federalists argued the Constitution did not need a Bill of Rights because the people in the states kept any powers not given to the federal government. Anti-Federalists held that a Bill of Rights was necessary to safeguard individual liberty. Myself and Mr. Hamilton were devout Federalists. Madison, then a member of the U.S. House of Representatives, went through the Constitution itself, making changes where he thought most appropriate. But several representatives objected that Congress had no authority to change the wording of the Constitution itself. Therefore, Madison's changes were presented as a list of amendments that would follow Article 7. The House approved 17 amendments. Of these 17, the Senate approved 12. These 12 were sent to the states for approval in August of 1789. Of those 12, 10 were quickly approved or ratified. Virginia's legislature became the last to ratify the amendments on December 15, 1791. The Bill of Rights is at its heart a list of limits on government power. For example, when the founders saw the natural right of individuals to speak and worship freely was protected by the First Amendment's prohibition on Congress from making laws, establishing a religion, or abridging freedom of speech. For another example, the natural right to be free from unreasonable government intrusion in one's home was safeguarded by the Fourth Amendment's warrant requirements. Many years and many changes later, there are 27 times that your country has changed the Constitution. These 27 amendments briefly summarized as follows. 1, freedom of religion, speech, press, assembly, and the right to petition the government. 2, the right to keep and bear arms. 3, soldiers cannot take or live in a person's house. 4, government cannot arrest a person or search their property unless there is probable cause. 5th, the government must follow the law, due process, before punishing a person. 6th, a person has the right to a fair and speedy trial by a jury. 7, the person has a right to a trial by jury for civil cases. 8, the government cannot demand excessive bail or fines or any cruel and unusual punishments. 9, the Constitution does not include all of the rights of the people and the states. 10, any powers that the Constitution does not give to the federal government belong to the states. Following the 10 amendments in the Bill of Rights, 11 more times you would change the Constitution. 17 times you would adjust the Constitution. 11, citizens cannot sue federal courts. 12, the president and vice president are elected on a party ticket. 13, slavery is illegal in the United States. 14th, every person born in the USA is a citizen. An immigrant can become a naturalized citizen. 15, all U.S. male citizens have the right to vote. 16, Congress can tax income. 17, the people can elect U.S. senators. 18, alcohol is illegal. 19, all U.S. female citizens have the right to vote. 20, the president is inaugurated in January. Congress begins to meet in January as well. 21, alcohol is legal again. Each state can make laws about making, selling, and drinking alcohol. 22, the president cannot serve for more than 2 terms. 23, U.S. citizens in the District of Columbia have the right to vote for president. 24, it is illegal to make a citizen pay a voting fee or take a reading test to vote. 27, if the president dies or cannot serve, the vice president becomes president. If both die, the Speaker of the House becomes president. 26, U.S. citizens who are 18 years old or older have the right to vote. And as this wise gentleman points out, the 27th and last amendment sets limits on when and how members are paid. These changes in the document before it comprise the ultimate law of the land. As I close and my time with you grows shorter, I ask each of you to take with you a copy of the Constitution. And as I said to begin, at your leisure, read it, know it, think on it. The world has moved far beyond what we could have conceived, but even with this, we did our best. And we left for ourselves and our posterity an opportunity unlike any the world has ever known. Protect it by knowing it, defend it by adhering to it, force those who represent you to know it and adhere to it too. Any one part of it may overpower the other if we, the people, do not know what is enshrined here. There are great available avenues of study, and my poor and limited time prevent greater detail on any of the sections. Much nuance and debate still exist, and I entreat you to do your best to study and know this document and its import in your citizenship. I most courteously thank you for your time and attention. I wish you well, and may God bless you. May God bless America.